of Appeals in Dallas, Texas is now in session. Justice Peterson presiding.
Good morning. We're ready to hear argument in case number 0519-00343 Commerce Street Capital LLC versus Durant Bancorp Inc. et al. Are both sides present and ready?
Yes, Your Honor.
Yes, Your Honor. Would the court like us to address the jurisdiction issue first before getting into the bulk of the arguments?
Yeah, please, if y'all could both address that at the top of your arguments. There was a motion filed to equalize time or to switch the parties' roles. And as y'all have seen the order, the way this is going to work is the appellant will have 20 minutes and then the appellee will have 25 minutes. And then the appellant will have an additional 5. You see one of your screens has a timer. Go ahead, Justice Whitehill.
I was going to suggest, why don't we deal with the jurisdictional issue first on an untimed basis before we get into the arguments. And since this just came up yesterday and
okay,
what have you.
Well, how do you propose we proceed, Justice Whitehill?
Whoever thinks we have jurisdiction ought to go first, I think.
Okay, who thinks we have jurisdiction?
Your Honor, Commerce Street Capital, the appellant and cross appellee does.
All right. Justice Enoch, do you believe that we have jurisdiction?
I tried to find how you would. I hate to be wasting our time today, but I was not able to find it, and I'm prepared to make the argument.
Okay. Well,
and let's assume we don't have jurisdiction. What would be the remedy? Is it a dismissal or a remand for the trial court to take up the issue?
All right, I'll begin with that question. I believe the appropriate thing to do is to remand on the limited issue where Judge Hoffman stated that the appellate fees would be up to $75,000. And I would respectfully direct the court's attention to a couple of cases that actually address this directly. And that would be the Grisham case, recently decided in 2018 by the Dallas Court of Appeals. And in the Grisham case, you had a 3rd amended judgment and then a 4th amended judgment. And the question was which judgment was the one that was actually the final appealable order. And this court found that the 3rd amended judgment was the final appealable order. And specifically in that case, this court held that a judgment such as the 3rd amendment judgment before the court there was appropriate. And this court held that a judgment settling all legal issues and rights between the parties, however, may be final and appealable even if further proceedings may be necessary for purposes of its execution, or an incident or a dependent matter remains to be settled. And if we actually look
in this case, if this judgment were handed to a sheriff to go exercise writs of execution on, how much property would the sheriff know to gather?
Well, okay. So for example, it depends on whether or not there has been an appeal. If no appeal had been filed by either party, in that case, there are no appellate fees and that number is 0. If it is after this Court of Appeals renders a decision, then at that point in time, the judgment is going to be what are the amount of attorney's fees up to $75,000. So otherwise, here's the flip side to this coin. If this court were to find that a trial judge, such as Judge Hoffman, must say what the attorney's fees will be if a party appeals, and the party doesn't actually incur that much money in attorney's fees. So here it was up to $75,000. And then there was only $50,000 that were actually incurred. Then guess what? If we had, Judge Hoffman will have given the lawyers a windfall of $25,000 that they never actually incurred. And that is the slippery slope you go on if you say that there's no jurisdiction here. You're telling Judge Hoffman, establish exactly what that amount of appeal price should be and award it, even though you don't know what the issues on appeal will be, how many points of error there will be. Surely you have seen many cases where there have been numerous points of error, where many of those points of error are weak and some of them are strong. That's not the situation here. The actual points of error briefed by the parties were pretty precise. But if Judge Hoffman were to be required to say, I'm going to guess, and I'm going to say it's going to cost $75,000, then you're creating a situation where a windfall could result for the party who's incurring those fees. The Kelly versus Isaac case will in fact also be indicative of and support that position, because in that case, the Court of Appeals in 2020, and I believe Judge Peterson was on that panel, held that there was a contingent award of appellate attorney's fees. That contingent award of appellate attorney's fees was not specified, and yet that was affirmed. And then in Yowell, I believe is the name of the case, that's another recently decided case where there were contingent attorney's fees that were unspecified in the order that were upheld. So I finally want to go back to the, I believe it's pronounced Romus Venture case, where the Texas Supreme Court says that the appellant can drive that cost up. And if the appellant does drive that cost up, then the court must provide an amount of attorney's fees that is reasonable under the circumstances. So you look at the entire circumstances. And finally, I believe that the order itself must be reviewed, and the order itself says, let me grab the order. It says at the very end of the order of the final judgment, it says, the final sentence says, this is a final judgment and finally and completely disposes of all parties and claims and is appealable. And so all three of these cases stand for the proposition that you look at the judgment as a whole and determine, did this judge intend for all of the issues to be resolved in this judgment? And that is exactly what Judge Hoffman does in this sentence by saying it's a final judgment, saying it finally and completely disposes of all the parties and claims. And under the three cases that I have cited, you look to the judgment as a whole and determine whether a reasonable person would conclude that this was supposed to be a final appealable judgment, and it is.
Okay, I see that the clerk has started the timer.
I'm sending her an email now asking her to reset the time.
Well then, Justice Enoch, do you want to briefly just respond and address that?
Yes, Your Honor. I spent quite a bit of time looking to try and save the time we've put in on this appeal to say that this court could determine it's a final judgment. But as recently as April of this year, the Texas Supreme Court came back down with another case on whether a judgment is final and therefore subject to appeal. It's the Bella Palma case. It's 2020 Westlaw 189854363.
Say that again, please.
It is 2020 Westlaw 189854363. Bella Palma takes on the issue that a judgment, even if it says it's final, even if it says it disposes of all issues, even if it uses the Mother Hubbard clause, is not necessarily final. The order on its face must show that it has disposed of all issues and all parties, or express clear intent that it's a final judgment. But the expression of a clear intent that it's a final judgment cannot overcome the face of the judgment, which leaves a fact issue open later to be decided. This is not a case that is covered by Grisham or Kelly, as cited by Mr. Kennedy. It's not even a case that's covered by Keith versus Keith, which we've looked at. And Keith versus Keith is 221 Southwest 3rd, 156. In every case, the evidence was what the fee would be, and the judge declared that would be the fee. The question was, in these cases, did the judge fail to condition it on success on appeal? And if the judge did, this court has the authority to modify judgments and could make the award of attorney's fees contingent on winning the appeal. In other words, if the appellant who was awarded the fees did not win on appeal, this court would have the authority to reverse that award out of the trial court because it was not based on winning. And that's a question of law. That's not a question of fact. That's a question of law. Now, Mr. Kennedy refers to discussions in cases where they don't identify what the fee was. But nobody in those cases is arguing there's not an identification of a fee. They're all arguing that the award of the fee was contingent or not contingent on winning on appeal. In fact, this court's very familiar with that because this court has dealt with that on numerous occasions. We have a judgment that requires a hearing, factual disputes to be resolved. Still in this judgment, it makes it not a final judgment. Now, there's the ultimate outcome could be just a matter of days. It could be that this court says we don't have jurisdiction, send it back. The judge says, no, I intended to award $75,000 or I intended to award $50,000. But there will be a hearing to determine under Yao at least the best estimate that Mr. Kennedy can come up with based on reasonable hours, based on reasonable time, based on the types of issues to be addressed, and the court then determines a number contingent on winning on appeal. We come back up. This would have been a premature notice of appeal. We might even not have to do any further briefing, or maybe there'll be some other briefing, but we could be back in just a few months to argue this case and argue the merits of the case and dispose of it. But in the question of jurisdiction, once the court concludes it does not have jurisdiction, it doesn't have the authority to move forward. Mike and I've already done a bunch of briefing. Mr. Kennedy's done briefing. You all are familiar with the record. We're ready to go. The problem is that we just can't without jurisdiction. I've looked. I wish we could. But this court simply does not have jurisdiction when the judgment requires us to go back to the trial court for a hearing to determine the appellate attorney's fees. Now, on the question of just kind of remand for the narrow question of doing fact finding by the trial court, that doesn't get us there because either the court has jurisdiction or it doesn't have jurisdiction. In any case where the court had jurisdiction, but example is happened in this case, a supersedes bond is a fight. This court could send it back for the trial court to do some fact findings so this court could resolve what it otherwise has jurisdiction to resolve. But this appeal is based on a final judgment. Final judgment is what's necessary for jurisdiction. I'm sorry. I wish this court had jurisdiction, but it just doesn't. And on that, may I say, we're all prepared to go forward, but actually once the trial court makes a decision that becomes final, there may or may not be some other points. The judge has not seen the full argument we've made on the $1 million award that has zero evidence. And so I don't anticipate the judge is going to change judgment, but it's possible that this case comes in a slightly different posture. Maybe not. It could be back in months. But I suggest we stop now. We send it back to the trial court to enter a final judgment, and then we can be back up in a matter of months and kind of evaluate what issues are still left to be argued.
At the very least, we have a pretty good estimate of what your appellate fees might be since you've already spent all of them. Mr. McKee, you have another comment?
I do, Your Honor. So I think the appropriate thing to do is to go forward with the argument and allow for supplemental briefing to the Court of Appeals on this, since no one covered the briefing, and this is the first time it's been addressed. However, even if we don't have supplemental briefing, the logic that has been espoused here is that the order on appellate fees is contingent. Well, then so is the provision that plaintiff shall have and recover taxable costs, because that is contingent on an award of on a successful appeal, correct? It's also contingent that we recover post-judgment interest. We don't recover post-judgment interest unless we are successful on appeal. Then is every judgment by every court now invalid because it didn't have some sort of herein before, never seen magic language that now it's required to be in every single court order that says, if you are successful on appeal, then you get to recover post-judgment interest. If you are successful on appeal, you shall recover taxable costs. And if you are successful on appeal, then all writs and processes for the enforcement and collection of this judgment and the cost of court shall issue as necessary. So now what we're doing is we're inventing law. We're inventing magic language that must be inserted into every judgment. And as a practical matter, it makes all of the judgments before this court at risk. Or you can deal with the easier answer. And sometimes, according to Occam's razor, that's the best one. And Occam's razor says the easier answer is the one where you identify all of the issues that are in this order that are absolutely final and decide upon them, and only remand the issue where the judge said up to $75,000 and determine whether or not that that requires further proceedings in the trial court below. Or you can also follow the cases that you've already issued on this matter in Graham and in Yowell, and as well as follow Ramus Venture. Thank you.
Your Honor, a comment about some the post-judgment interest costs all are assessed at the time of the judgment. There's nothing on the Court of Appeals that changes that unless the judgment changes by the Court of Appeals. That's a different question. Pardon? I'm sorry, Your Honor.
I have a question for you. Would a hearing be necessary before the trial court if the fees were below $75,000? In other words, can we infer that the trial court has already found that any fee up to $75,000 is reasonable and necessary?
Your Honor, I guess you could infer that, but this court would be required to make a fact finding on what a reasonable and necessary fee was for the actual appeal that occurred. So it doesn't avoid going back to the trial court to determine what should that fee be. And Yowell actually talks about this. Yowell recognizes that fees on appeal are by definition hypothetical. It recognizes the problem. It says that still doesn't excuse the party from testifying to what hours were spent and what services were provided, and that the rate was reasonable and it was reasonably necessary. So what you do is you put in front of that, I anticipate X number of hours will be required to do this appeal. My rate is X dollars. I anticipate that will be a reasonable rate for performing these services in the appeal. And as a result, my best educated estimate is this amount of money. Yowell says that's okay. That is some evidence upon which the judge can render the dollar sign. But that's not the evidence if the judge says, well, I have no idea how much time I'm going to spend or how much, but I'm going to cap it at $75,000. That's not what the judge did here. We've got to go back for that judge to decide what the estimated fee will be. And I wish I wish that we could sit there and say, well, we've got a point of error that there's zero evidence of reasonable appellate fees. There's nothing about reasonable. There's nothing about time spent, nothing here. And I wish this court could just sit there and zero that out and then move on. The problem is, for the court to do it, the court has to have jurisdiction in the first instance to make that rendition. It's a very difficult problem. I wish we didn't have that here, but I see no alternative except it's not a final judgment. We go back. We'll find out what the hearing produces.
Well, Mr. Enix.
Yes, sir.
Both of y'all are experienced counsel. How many other judgments like this have you seen where there's an up to appellate number for appellate fees? I've been doing this 38 years and I've never seen it before.
Well, Your Honor, I'd have to confess that this is the first judgment I've seen by it. We did object to the award. We did object that it was improper in our motion for new trial and motion to modify the judgment. But quite frankly, we had never seen a judgment like this before. Otherwise, we would have said there's no jurisdiction for the appeal. It would be premature. But we did ask the judge to fix that before it came up on appeal. And we got up here on appeal by Mr. Kennedy filing first, claiming he was entitled to more attorney's fees. So we're here.
Well, actually, that's not exactly right. I think Justice Enix seems to have forgotten that we had, Justice Enix seems to have forgotten that we actually had an evidentiary hearing on the issue of the appellate attorney's fees in addition to attorney's fees below. And at that hearing, we provided evidence of what the appellate fees should be. And I argued that it should be no more than $150,000. And the Honorable Judge Hoffman reduced that to $75,000. So there was a hearing, there was evidence, and none of that evidence was contradicted, even though they had an opportunity to contradict it. So all of that is in the record, and it establishes what a reasonable amount of attorney's fees are. Now the question is whether or not, and I believe Justice Whitehill's question was, have I ever seen a judgment that said up to? And absolutely yes. And in many cases on appeal, such as a patent infringement lawsuit, which are many cases that I handle, we have no idea what matters will go up on appeal. Could be the invalidity, it could be infringement of claim 1 or claim 2, it could be the claim construction, there could be discovery issues. For example, in this case, they tried to get into evidence during the attorney fee argument, a document that was a settlement document. They tried to get into evidence a settlement document as part of the attorney fee dispute. We have no idea.
If I can, I think that we need to move on to the merits. I think that you're getting into the merits of the case at this point.
Very good. Well, absolutely. I'm happy to do that now if the justices all agree that that's where we should go.
Justice Whitehill, do you have any objection to that?
You know, I think we might as well. I don't know what to do with this thing. I'm very concerned about the jurisdiction question. Everybody's here ready to argue everything else. A lot of times when there's a question of subject matter jurisdiction, we carry it and resolve it in the opinion. So I guess I lean towards let's just go ahead and argue the merits, and we'll figure out the jurisdictional issue later. What we can do with it, whether A, do we have jurisdiction? B, if we don't, is it a remand or is it a dismissal? Those are three questions we got to figure out. First one first, I guess. But while we're all here and we're all ready to argue the merits, we probably ought to go ahead and do that.
All right. Well, I just for clarity for the clerk, for Ms. Matz, sorry for the confusion, but I guess let's go ahead and start running the timer and begin addressing the merits, and then we'll take up this jurisdictional issue in conference, and we'll provide further guidance as soon as we have a decision on that issue.
I do think supplemental briefing on the jurisdiction would be helpful.
Sure, absolutely. That'd be very helpful. Sorry to interrupt you there, Mr. Kennedy. You want to go ahead and start, I guess, addressing the merits?
Well, thank you, Justice Peterson. First of all, it's good to see you all again. And I want to begin by discussing the standard of review for this case, because the standard of review is where we begin everything. And the standard of review on the issue of the breach of contract action is that it is first of all, a determination that the contract itself is unambiguous. None of the parties have ever taken the position that the contract is ambiguous. That would have been something that would have to have been pleaded as part of the parties' pleadings, and none did. So since it's an unambiguous contract, the Court of Appeals reviews the terms of the contract as a matter of law under Pathfinder, and then the court should consider the entire writing in an effort to harmonize and give effect to all the provisions, so none will be rendered meaningless. And no phrase should be isolated from its setting and considered apart from other provisions. That's a direct quote from Pathfinder. Then what this court does is review the evidence and determine whether the evidence is legally sufficient to support the judgment awarding Commerce Street Capital $4.6 million in its success fee. And this is an extremely difficult standard to overcome. As the court in City of Keller said, the final test for legal sufficiency must always be whether the evidence at trial would enable reasonable and fair-minded people to reach the verdict under review. And the appellate court must review the evidence in the light most favorable to the verdict, crediting favorable evidence if reasonable jurors could, and not disregarding contrary evidence, etc. So that is the legal standard for the breach of contract. On the issue of appellant's issue on attorney's fees, the issue is, was there an abuse of discretion? Briefly, on the issue of the amount of the attorney's fees awarded for the trial court, in that subset of the argument, the question is controlled by Romus Venture. And in Romus Venture, the court said there's a presumption now. There's a presumption that if you give your attorney's fees invoices, and they're broken down by lawyer, and they're broken down by the amount of time and the actual rate, and there's evidence to show that those rates are reasonable, then it is presumed to be correct and reasonable. Here, the only evidence in the record was expert testimony offered by Commerce Street as to the reasonableness of its fees, and all of the attorney's fees invoices, some 100 plus pages of attorney's fees invoices were provided to the court. And of those nearly 200, it was somewhere between 100 and 200 pages of invoices, single space. I think 12 pages had some redactions on them. And of course, we redact invoices so that we don't waive the attorney-client privilege and disclose things that.
So in your view, Mr. Kennedy, if I contest the other side's offered attorney's fees, do I need to present, my own number? Do I need to create, these are invoices that I think would be reasonable, or may the fact finder simply evaluate the proffered evidence and make the court made its own evaluation about the reasonableness and necessity of those fees?
What you're saying is, can the court take judicial notice of what a reasonable attorney's fee is? And the answer is yes. And there is a very recent case, I think it may be Yowell. There's a very recent case where the court said that the court may take reasonable notice or take judicial notice of what a reasonable fee is. The other thing that the parties should have done, they should have had their own expert. They should have put on their own expert testimony about what a reasonable attorney fee should be, and they declined to do that. So Here, Judge Hoffman, in all respect, he gave the wrong reason on why he was making the decision to reduce attorney's fees. He said he was disallowing the attorney's fees charged by Chelsea Spencer and David Ritter, who were partners at my law firm, apparently because of a challenge that I didn't establish that they were somehow competent lawyers. That is the incorrect standard. If he would have said, well, I'm finding that these lawyers, and by the way, none of their entries on the invoices were redacted. So the only fees that were taken out were unredacted invoice entries, and apparently he thought that I needed to establish that those lawyers were competent, and that is not the standard that the Texas Supreme Court provided in Roma's venture.
What was the trial court, as the fact finder in this instance, permitted to consider all the evidence and as a factual matter determine that he didn't find those fees were either reasonable or necessary, just as a factual matter?
He could have said that, absolutely, and that's what he should have done. Instead, the record reflects that he said you didn't show any evidence that these two lawyers were competent, and therefore you didn't reach you didn't satisfy your burden to demonstrate that these two lawyers were competent.
Did he enter findings of fact and conclusions of law in writing?
It's just on, no, he did not. It's simply as a matter in the transcript.
All right.
I'd like to move to what I thought was going to be the hardest issue today. And what I thought the hardest issue was going to be today in my planning was the issue of consequential damages, because we have a very unique situation here where I completely agree with Judge Enoch that the state of Texas does not recognize as a form of damages damages for general reputation from a breach of contract. Although the recently issued international paper case kind of puts that all into question. But let's just assume for right now, because international paper is on appeal and we don't know exactly what's going to happen to it on appeal, that for right now, the only reputation damages available are damages to credit reputation. And Justice Enoch is correct that you are only entitled in a breach of contract case, as it is right now, before we know the full meaning of international paper, you only get damages to credit reputation. However, unfortunately, the issue that was presented to the jury question number 3, asked the jury to find what are the damages to credit and reputation.
Whoa, the precise question says damage to credit reputation. That was a natural problem. That's right.
All right, hold on, let me just grab that. Thank you.
Page 87 for the record.
Right. It says, question 3. So you've got, before question 3, you've got what sum of money, if paid now in cash, would fairly and reasonably compensate Common Street Capital for its damages. And then we get to question 3. For loss of credit and reputation, damage to credit reputation that was a natural, probable, foreseeable consequence of NAB's failure to comply. So in one sentence, it says for loss of credit and reputation, and then we have damage to credit reputation, and none of the lawyers objected to this specific question. So under the Federal Rules of Civil Procedure 274, by failing to object to the question, therefore, if it's deficient, cannot be after the fact overruled and decided on its own by the Court of Appeals, cannot on its own then say, well, question number 3 was defective, we have to throw it out. You either agree that no party objected to question number 3, and therefore any objections to question 3 are waived, and the jury verdict must stand because there is evidence in the record to support that finding, or you determine that, all right, question number 3 is clear what the judge intended. He intended damages to credit reputation, we're going to ignore the earlier sentence that says credit and reputation. It's just credit reputation. I will concede there is no evidence in the record for damage to credit reputation. And in that case, Judge Enoch is correct. If you come to that conclusion, that this court should reverse and render on that specific issue. On that specific issue, you should reverse and render because there's nothing in the record to support a finding of damages under for credit reputation. However, the problem isn't that easy. The judge said credit and reputation. No one objected to that question, and therefore any objections to that question are waived. And now we have to look at the sufficiency of the evidence. And is there anything at all in the record to support a loss for credit and, which is a plus sign, reputation? And that is where we get 0 for loss of credit, plus whatever the jury found was there for damage to reputation, and that equals the amount of damages they awarded for consequential damages, which is $1 million.
Mr. Kennedy, what witness gave the jury a number as to the damage to the credit reputation?
Dory Wiley, and he did that on the record, volume 4 of the reporter's record, starting at around page 200, and specifically on page 208, lines 12 through 18, Mr. Wiley testified that Commerce Street Capital may have lost numerous deals as a result of defendant's breach, and a conservative estimate of consequential damages would be the loss of 1 deal, half the size of the Durant NAB deal, resulting in a lost fee, which he said was $2 million. So in the record, you have it.
And so as the business owner, what qualifies him to give that? That sounds like an expert opinion to me. Tell me why I'm wrong.
He is the CEO of the company. And is that expert testimony? Well, if it is, no one objected to that testimony at trial. No one objected and said, objection, calls for hypothetical. And no one, at least not to my recollection, no one did that. And even if they had and the judge overruled it, then the proper point of error is to say that Judge Hoffman allowed in evidence that he should not have allowed. That has not occurred either.
I've got a question here. The theory of this damage is that somehow the investment banking community got the idea that Commerce Street lost the deal. But the theory of the case seems to be they were cut out of the deal. And if that's the theory of the case and the basis of the judgment, then how is their reputation hurt by getting cut out of the deal by somebody going behind their back?
Well, you're absolutely right. They did get cut out of the deal. And the question is, why were they cut out of the deal? That's the question. Why was Commerce Street cut out of this deal? And that 4 banks asked that question to Dory Wiley. That included Prosperity Bank, Bank of the Ozarks, Bank South, and Bank and Legacy, Texas. And that's on the record at volume 4, page 209 through 211. And the question was, why did Commerce Street Capital get cut out? Is there something wrong with Commerce Street? Why would they ever cut you out of this deal when we had offers lined up to $450 million? Bank of the Ozarks.
They didn't want to pay $4.6 million?
I'm sorry, I didn't hear you, sir.
They didn't want to pay $4.6 million?
Well, they didn't. That's probably the answer, Your Honor. Why didn't they pay that $4.6 million? They don't want to pay it today either. So it looks like I've got about 6 minutes left. I want to 6 minutes and 11 seconds in my 20-minute opening. So I also want to go over some of the breach of contract questions as well. Again, that consequential damages is the one that I thought was the most complex. That's why I sort of led off with that. The breach of contract case, I want to point out that the breach of contract action is not just based and shouldn't just be based solely on looking at the May 27th letter agreement. The court should also consider although looking at the March 27, 2014 agreement by itself demonstrates a breach, I think it also is informative for the court to also look at the non-disclosure agreement, which was entered subsequent to, but in direct relationship with this specific deal. So first, let me begin with, why is this non-disclosure agreement even being discussed today? And the reason that the non-disclosure agreement is being discussed is because there was an attorney named Paul Corley who wanted Commerce Street Capital to be the exclusive representative to negotiate between Durant and NAB only. And that was because the general counsel at Durant is a man named David Keese, and David Keese has a side law practice where he also represents NAB. So the lawyer, the outside counsel for NAB said, well, look, we've got an acquirer, Durant, whose general counsel is also giving advice to NAB. I've got to separate these two. And the only way I can is to make sure Commerce Street Capital is the only party that negotiates this deal. So the NDA should be read with that engagement agreement. And the non-disclosure agreement on the last page specifically identifies that the only party that would handle negotiations between Durant and NAB would be Commerce Street due to a conflict of interest of one of the lawyers in the case. And that non-disclosure agreement had a term of 4 years, and it was never, ever abrogated or otherwise terminated. Yet, they went behind Commerce Street Capital's back after Commerce Street Capital negotiated an offer from Bank of the Ozarks for $450 million. And then what we see happening is after Commerce Street Capital got them the number, they went behind Commerce Street Capital's back, and somehow in a 3-minute conversation, a deal got struck between NAB and Durant to buy it for $450 million. We, to this day, do not know how a $450 million transaction could be negotiated in 3 minutes between Greg Massey and NAB, the acquirer. Was it because there was a conflict of interest? Did they ignore that conflict of interest? We will never know. But that NDA is telling, and it sheds light on the contract as a whole. Now, the contract as a whole requires that Commerce Street Capital identify and screen potential acquirers. And what does identify mean? The other side wants to read into this language that Commerce Street Capital had to be the first to identify. And if Commerce Street Capital wasn't the first to identify, then somehow Commerce Street Capital can do all of this work and negotiate a deal of $450 million with Bank of the Ozarks and then get cut out free of, with no consequence. Sort of a heads they win, tails we lose. No matter how we do it, we walk away and get nothing. And that's just not what this agreement calls for. The word identify and screen says, the definition of identify means to state the name. Screen requires actual work looking at whether this party is appropriate for this deal. Commerce Street Capital, there's evidence in the record of Brian Johnson at 5 Reporters Record, page 175, 176, where he says at a meeting in June of 2014, Commerce Street Capital was the first to identify them. And after Commerce Street Capital identified them, during this meeting with NAB told them, no, we do not want to be acquired by Durant because of Greg Massey. So he wrote in his notes for that day, no Greg Massey, even though Commerce Street Capital identified them. Commerce Street Capital screened Durant's bank offer when it came in. That's found at volume 8 of the Reporter's Record at 644. You can also look and see in writing that Commerce Street Capital identified Durant in volume 8 of the Reporter's Record at pages 397 through 98. So we have all kinds of evidence, legally sufficient evidence to support the jury's finding that Commerce Street Capital identified and screened a potential acquirer and was even the first to identify and screen that acquirer. And therefore, they satisfied the condition precedent to earn their fee of $4.6 million. And why they cut us out of the deal, why they cut Commerce Street Capital out of the deal, we may never know. But it certainly, the jury certainly was not persuaded that Commerce Street Capital didn't do what it was supposed to do under the contract, and they gave us the award of $4.6 million. I see my time is up. I'll reserve my remaining time.
Thank you, Mr. Kennedy. Justice Eno.
May it please the court, I appreciate the court giving me some additional time here. Based on the court's questions, I believe that the issue on the attorney's fees is not that important to this litigation, nor is really the loss of credit reputation. The main case is, are they entitled to the success fee? We don't believe they are, but I do want to address briefly at the beginning the main point that he brought on his appeal, which was the attorney's fees. And I realize I don't have the opportunity to have the last word on the main points of the brief, so I'll try and cover as much as I can during the time available. First of all, I want to address the credit reputation case. As a matter of law, CSC cannot recover damage to credit reputation or damage to credit or loss of business reputation under the claims in this case. Even the trial judge on the record said he didn't think there was any evidence of loss of credit reputation. How we ended up with a judgment for $1 million on that amount is baffling to NAB and to Durant Bank. But let me talk about that. We objected the charge. We have an obligation, if we don't like the question that's asked, to submit a separate question. But if we're objecting to the instruction, we have no obligation to give the correct instruction. CSC, it really doesn't matter if CSC is bound by instruction of credit reputation or if they're bound by the question of whether it was credit and reputation. There simply is no authority in law that permits a recovery in this kind of case, nor is there any facts in this case that justify the recovery. The Supreme Court in Meade versus Johnson and this court in EMC Mortgage said these damages, referring to credit damages, in a suit where damage to credit was the necessary and usual result of the defendant's actions, is required. Loss of credit is not in the usual necessary result of their actions. This was not a credit transaction. Every one of those cases deals with promises of a loan, promises of funding, something that falls through. Virtually every case. That's not this case. This was a success fee by a broker. If certain conditions were met, you'd be entitled to a success fee. In this case, $4.6 million. Texas Mutual is a Houston case, and Rubalcaba is an El Paso case. Both of them say the loss of business reputation is not an element of damages recoverable for breach of contract. This is a breach of contract case. Those kinds of damages are not recoverable. You read those cases, they're going to say defamation. They're going to say someone said something specifically to harm your reputation. That's not this case. That's not even the evidence of this case. And I'd show you the page on Exhibit 3 that I've provided to you, page 3 of the exhibit, which I provided to you. As a matter of law, here's page 3. It actually is the testimony, all put together in one summation on page 3 of your exhibit. Here's the testimony. As a matter of fact, there are no evidence of damages. Their COO, Bobby Hashaway, said, I'm not generally aware. I can't personally identify one. What's he referring to? One instance of business lost. Doherty Wiley, which Mr. Kennedy has identified, here's his testimony. But as for us, we're just saying, heck, if we lost one deal that was half the size of $2 million, that's how I'd come up with a number he asked, which I think is pretty conservative. There's no evidence of losing any deal except this one, and they're claiming this one caused some sort of harm to the reputation. Tex Gross, which is also there, and I've got the record sites. I cannot name a specific instance was his testimony. As a matter of law, credit or reputation is not recoverable. This is a breach of contract for a success fee. If they're successful, they're entitled to a success fee. If they're not entitled to a success fee. There was no credit transaction that we failed to fund something they said we'd fund, or we somehow deprived them of an opportunity to go get funding someplace else on this transaction. There is no credit issue here. There's no reputation issue here. There's no claim that we said anything that would harm their reputation. I think that ought to be reversed and rendered. I believe the court should reverse and render it. And when it does, that also requires the attorney's fees to be reversed and rendered. Now, whether or not they get remanded, that question is simply because they got an award for 4.6 plus $1 million. We're going to have to reassess their attorney's fees, which were based on the trial court's judgment. The trial fees will have to be further segregated to subtract what they lose on the $1 million. But we don't believe that they even get the entitlement to retry the attorney's fees. And so I'll address that very quickly. The court is very familiar with Romus. What do you have to show? Of the elements that you have to show in Romus, you've got to show the reasonable amount of time required that each person performing the services retired had their reasonable fee, and you have to show the particular services performed. When you get to Yale on the appellate fees, you can estimate. But the one thing you can't and are not excused from showing is that your estimate is based on a reasonably necessary fees and reasonable hourly rate. I've cited to you on record, well, supplemental record 12 to 25, 53, 26. It's all in the brief, in the supplemental record. I wasn't saying to Mr. Kennedy he had no evidence of appellate fees. What I was saying, there was no evidence of fees. We had a hearing, certainly we did. But it's not that you have a hearing, it's what you testified to. The bills in the trial were heavily redacted. Romus requires identifying the work you did. You can't just simply say, well, I took 2 hours to prepare blank. When you get to the Court of Appeals, you also have to have testimony reasonably necessary. There is no evidence on the appellate fees of what's reasonably necessary. Now, the argument that CSC makes, well, Lodestar is presumptively proper. Well, Lodestar is presumptively sufficient of the time spent and the amount incurred, but it is not sufficient to establish that that's reasonable or at the time was reasonably necessary. I can give you a number based on Lodestar, but I must still testify that my rate is reasonable for the time provided and the services were reasonably necessary. When Lodestar comes in, it says it kind of satisfies all of the Arthur Anderson things about how much extra time I took or I was taken away from other times. He says that kind of substitutes for that underpinning, but it doesn't substitute for reasonableness. We believe that when you look at the evidence in this record, there is a lot of, I'm familiar with the usual charges. I'm familiar with handling appeals, but the main objection is there is simply no reasonable number of hours being needed or reasonable rate that's being charged, certainly for the appellate fees. And we think the court could reverse and render on those. But as I said, I think part of this judgment at a minimum has to go back. And so there'll have to be a rehearing on attorney's fees, assuming the court thinks there's some evidence. Now I want to address the main issue with the time I have left. This is CSC entitled to a success fee for this transaction? I need to begin the court with what it's very familiar with. The Supreme Court has been adamant. Every year there's one or more cases where they are adamant that people are bound by their contracts. They're adamant. Courts don't get involved in these kind of rewriting contracts. They are adamant. The jury doesn't decide if a contract's ambiguous, and then what it decides, the trial court decides whether it's ambiguous. Then if it is, then a jury will decide what the contract means. But in the first instance, the courts do not interfere with what the parties contracted for. And the reason the court says that is litigation over a breach of contract almost invariably includes a client, a party, who really in their own mind said, I wish I had a different deal. And then they're going to put forth the best evidence they can of why the deal they wish they had is the deal they actually had. Courts have to be wary of that kind of argument that's being made. In this case, this was a contingent fee agreement. It's a success fee. Conditions have to be satisfied. This isn't a case where I did all this work and gee gosh whiz, I got cut out. This is not a case where they interfered with my being able to negotiate. This is a case that had specific conditions, and the conditions, were they met for their determination? We've recited the court to Pathfinder, and in Pathfinder, it says what the Supreme Court's been saying for years. You read the agreement as a whole, and you give effect to all contract terms. We agree there's an agreement from May 27th. We agree it has a number of terms that this court must read together. Mr. Kennedy argues, CSC has argued, and they argued at the trial court, oh, but you can't look at those documents alone. You got to look at something else that occurred. An NDA that's not even with CSC. It's between CSC and it's between Durant Bank and NAB. But taking that for a moment, let's look at the contract that the parties signed. And it's your exhibit, it's page 1 of the exhibit I've provided to you. And I want to talk about the first thing, description of services. This is the parties' agreement. CSC will identify and screen potential inquirers. And then it has items 2 through 7 of specific services they will perform. And then they get to provision 8, which says that they will assist in all aspects of the sale. Assist in all aspects of the sale, not run all aspects of the sale, not exclusively handle all aspects of this. It's assist in all aspects of the sale. And why is that significant? Look at the next sentence. In addition, CSC will represent the company should the company identify any potential acquirers and will have the same responsibilities as outlined in items 2 through 8 above. There is no question that they had responsibilities to do. There's no questions that in this very agreement, in that very provision, they know that they have a responsibility to perform all of those same actions, even if CSC is the one that identifies the acquirer. So now I call the court's attention. It's page 2 of the exhibit. This is the June 19th, 2014 handwritten memo by Brian Johnson. I've cited you to the record on the exhibit. This is a handwritten memo. It's about 3 or 4, well, it's not a memo, it's notes. And it's about 3 or 4 pages. Brian Johnson says he met with NAB as one of the first things they did to begin the process under that May 27th letter. This is where they met to begin the process. Now, I know Brian Johnson says, well, after 4 years, I'm not sure really how to, but I'm sure I must have been the one who said Durant Bank. That's not what his notes show. His notes show that he sat down with Joe Rushing of NAB to discuss. And Joe Rushing said, not Greg Massey. Where did the name Durant Bank come from? It came from Joe Rushing. And we provided you all the background information in the statement of facts about Joe Rushing and Greg Massey having been friends for years and been back and forth on whether they buy or don't buy. What that refers to, and I'll tell you why that matters in the next page, how this matters on what that means is goes to the next page. And I'll call your attention back to exhibit number 1, page 1. Let's look at the next question. Identify and screen. The expiration condition. This is it. CSC is entitled during the tail period, that last 24 months, to the full success fee if it's the one who identified and contacted Durant Bank. How is that material to this case? CSC does not dispute, well, actually, Mr. Kennedy gave you part of the definition, but the identity to recognize or establish as being a particular person or thing, yes, that's identify. But Mr. Hashaway, the chief of operations, chief operating officer, testified this. What does that mean? You are a party. That means the criteria of what you're looking for. Remember, a particular person or thing, of the criteria that you're looking for, the transaction you're trying to do. If you think that party meets that qualification or whatever, you identify them as a candidate.
Mr. Justice Enoch?
Yes.
That's one definition that was put to the jury, but during Mr. Johnson's testimony, he was asked what the word identify means to him, and he said the word identify to me means to recognize or to know someone. And then the next question was, during this meeting, did Commerce Street Capital identify any potential acquirers? And he said, yes, we did. And who did Commerce Street Capital identify at this meeting? Mr. Johnson testified, we identified Durant Bancorp. And then to explain his notes, he said in that discussion, we, meaning Commerce Street, brought up whether or not the client wanted to include Durant as a potential acquirer. And from that, the client indicated to us that it did not want to include them in the process. And that's why I wrote no Greg Massey down on my notes. So couldn't the jury have credited this testimony and found that Commerce Street did identify Durant?
No, for the claims that were brought. This was a claim that during the tail, those last 24 months, that CSE satisfied the condition to get full return on its success fee. What did the tail require? The tail didn't require I identified them. Yes, CSE says I identified them. Yes, during the contract, if they had identified them, they had to work on it. If NAB identified them, they had to work on it. The question was, after the contract expired, during the tail, and a transaction closes, CSC, if it identified and contacted the party, it got the success fee. It is immaterial that CSC identified them. I think that's not what happened. I think what happened is NAB said, listen, we've had long deals with Greg Massey. We don't think we want to talk about it and not going to. But here's what the rest of the evidence was. On June 24th, this is after that June 19th meeting, CSC has an interperson email advising that Greg Massey contacted Joe Rushing, and Joe Rushing said CSC is going to handle this and referred Greg Massey to CSC. The first written indication we have of any contact in this case is Joe Rushing telling Greg Massey to contact CSC to handle it. The next document in this case, July 15th, this is almost a month later, not quite. CSC's internal records show attached is the very first edition, of the call list for this project, referring to the sale of NAB. And on July 18th, again, this is cited, it's in the court's record. On July 18th, 3 days later, an internal email is from a Preston Simmons, and the email very clearly states, this is the most recent call tracking, the most recent tracking list for your information. And that's the first time Durant Bank appears on that issue. I can appreciate that CSC put in a lot of business, put in a lot of time. Well, actually, I think the evidence is disputed, but I'm going to concede that they could get up there and say, oh, we spent all this time. Yes, we even got them a better deal because we found somebody else who was willing to pay more. They can say all they want to say about it, but they can't have a contract that's the one they wish they had. They can't come back and say, well, I know the transaction didn't close during the term of the contract. I know that we didn't contact this person during the term of the contract because NAB made the reference to CSC for the contact. But gee gosh whiz, they closed it and we ought to be able to get the success fee on that. I want to address one other part. Mr. Kennedy has also raised a number of, well, there's a breach of exclusive negotiations. There's a breach of, the NAD, those kinds of things that are out there. Well, I call your attention again to page 1 of the exhibit. This is the contract. The only exclusivity there is the CSC has the right to be the exclusive investment banker for the acquirer. There's nothing here that says that they are exclusively negotiating or they're exclusively participating in this activity. Nothing about that. And in fact, the contract says that if if NAB brings a buyer to the transaction, then NAB, that CSC is required to assist them. Well, maybe they didn't use their assistance. Maybe they did get it done. But the truth is, are they entitled to the success fee? And I believe the contract conclusively says you satisfy this condition, you identify them, and you contact them. We may have an argument about who identified. I don't think the evidence even is subject to dispute. I believe Brian Peterson sat in that meeting with Joe Rushing, and they went through various candidates, and Joe Rushing said, not NAB, not Durant Bank. But even if you say, well, there's some evidence about that, there is no dispute, zero dispute from their own documents that the contact came as a result of Joe Rushing telling Greg Massey and his folks to come through CSC.
Okay, but I want to focus on the contact aspect during the term.
Yes.
Is it your position that no matter at whose instigation, there was no evidence that CSC contacted NAB during the term?
There is no evidence that CSC identified and contacted. I mean, their argument will be if all we did was contact and we satisfied, but the point of NAB bringing someone to the table is the tail doesn't apply unless they identified them and they contacted them.
Well, isn't the tail pretty much a standard protection clause to make sure that somebody doesn't get cut out of a deal? I mean, we've seen this in many, many contracts.
Admittedly, but nobody says that if I don't satisfy the condition for the tail, I still get it because they interfered with me or they kept me from doing it. Or all I had to do was identify. I didn't have to follow through.
But sir, isn't there an allegation or evidence that they actually negotiated with Durant and increased their offer?
Your Honor, admittedly, I will accept that they did a lot of work on the case. I think it's disputed in the evidence. I think there was not a lot of work on the case, but they did have Ozark Bank that made an offer. There's no question.
But sir, how could they have negotiated with Durant with the result of Durant increasing its offer without contacting Durant?
Your Honor, I think the evidence was that they were responsible for getting Ozark's different bid, which forced Durant to go up to $450. But as Mr. Kennedy said, We must have negotiated that deal because they said they made the deal in 3.5 minutes, and I don't believe that. The question is, yes, they did a lot of work. They brought Ozark to the table. It produced a different number. Durant Bank adopted that number. That's not the same thing as when we're in the tail. The transaction did not close in the first 2 years of the agreement. We're in the tail. The question is, admittedly, they did a lot of work, but they agreed that if it didn't close when they had the contract, they were still entitled to a success fee if during the term of the contract, they identified and contacted. If that's not the case, then they're not entitled to the success fee at the other end. That's the issue that they argue is, well, we're somehow saying we had to be the first to identify. The provisions in the contract about whether NAB identified the person or whether NAB or whether CSC identified and contacted, those provisions are meaningless. Under the facts of this case, if you can determine, it doesn't matter when the contact occurred, it doesn't matter who identified first, NAB could never have avoided this success fee, even if the contract had terminated. Yes, sir.
Thank you so much for your time.
Okay, sorry.
If I may proceed, thank
Please,
you.
whenever you're ready.
Yes, thank you, Your Honor. A couple of matters. First of all, in the testimony of Mr. C.K. Lee, Mr. Lee, which is in the record, I don't have an immediate cite to that, but I'll have it in just a moment, I'm sure. Mr. Lee testified, and it's quoted in our brief, that he actually met with Greg Massey in Durant, Oklahoma, at Durant's offices prior to the meeting that occurred in June of 2014. So just Mr. C.K. Lee's testimony alone shows that he contacted. So not only did Commerce Street identify Durant, the reason Commerce Street knew to identify Durant was because C.K. Lee, as part of his job, is to go and meet with prospective banks and know what their interests are. Mr. Lee met with Durant and asked them questions about what kind of banks they wanted to acquire. And Durant specifically said they wanted NAB. So that's how, in the very first team meeting, C.K. Lee was present along with Mr. Johnson. That's how Commerce Street employees knew to ask and identify Durant, because they meet with all of these bankers as part of their business. And they said, is Durant a potential acquirer? And at least at that point in time, they were told, no, Greg Massey. So I want to get and zero in on a couple of other issues, such as the term and termination language, because the term and termination language specifically states that Commerce Street Capital shall have the exclusive right to provide investment banking services with respect to the acquirer named above for 12 months, the initial term, with 2 6-month extensions. So it ends up being a 2-year deal. And during that 2 years, did Commerce Street Capital identify and screen? Well, that evidence has been established. And in fact, the analysis where Commerce Street Capital identified its investment banking fee, which is a part of the record in volume 8, page 644, you see the actual analysis where Commerce Street Capital picked apart their deal. And in that, they include a list of expenses, including Commerce Street Capital's expenses for closing that deal. So, and at no time did NAB ever voice the objection, you don't get investment banking fees for this, you need to take that out. At no time did they do that. They led Commerce Street Capital to believe that they in fact identified and screened and contacted Durant Bank at the appropriate time. Finally, I want to focus on the cooperate language, which is a very important term. The cooperation language, which says at the bottom of page 2 of the agreement, specifically says, company agrees to cooperate and, quote, will provide information reasonably required by Commerce Street Capital in connection with providing the services contemplated by this agreement. And what they did not do during the term of the agreement is tell Commerce Street Capital that they were negotiating a deal in May of 2016 and entered into a letter of intent with Durant after a 3-minute conversation to sell the bank for $450 million. They violated that clause, and the only way to cure that clause, Your Honors, is for them to pay Commerce Street Capital its fee. That's how you cure the breach of the cooperation clause. I've got about 37 seconds left. I want to take this moment in time just to say thank you for the opportunity to be here today. And during this time of uncertainty and during this time, I just want to say that the Court of Appeals making itself available on this platform has made attorneys very happy that we can continue our cases, continue to litigate. And we are so appreciative of this. This is what makes this country great. You 3 justices make our country so great because of what you do. And I thank you for that.
Thank you very much, Mr. Kennedy. We really appreciate the very able argument and excellent briefing by the parties' counsel. Please submit your supplemental briefing related to the jurisdiction question just as soon as you're able. And if we can resolve the case, we will. If we cannot, we will provide further guidance. And thank y'all so much.
An honor to appear before the court. Thank you.
Thank y'all.